Today I want to talk about international law. There's been some discussion recently about attacking cultural property sites in the Middle East. It is against United States law to do this. It may help if we can break this down into plain language. So my objective is to explain the law regarding threats to strike cultural property sites in the conflicts that are currently troubling the Middle East. I have no interest in advancing any political position in this discussion. My objective is simply to explain the law that applies to these matters. First of all, let's attempt to understand what is meant by the term international law, and then see how that fits into the law of the United States of America. Public international law is the law that governs relations between or among nations, or between or among international organizations such as the United Nations, OPEC, UNESCO, and many other organizations. This kind of international law is called public international law and has developed over the centuries by custom or by treaty. A treaty may also be called a convention, a protocol, an agreement, a covenant, and other terms. Generally, a treaty goes into force by virtue of its being signed by the head of state of the country joining in the treaty. However, under United States law, a treaty becomes effective only upon approval of the U.S. Senate by a 2/3 majority of the senators present. Once they have voted to approve the treaty, it goes into force on the effective date as provided in the ratifying instruments. Under United States constitutional law, Article 6, Clause 2, a treaty that the United States has ratified becomes the supreme law of the land. This means that it becomes a part of our federal law, just as the other enactments of the U.S. Congress. The relevant treaty in our discussion today is the Convention for the Protection of Cultural Property in the Event of Armed Conflict. The subject of this treaty has been of special interest to me over the last 30 years or so. It was the focus of my thesis for my degree in international law at the University of Brussels. This treaty was concluded at The Hague on May the 14th, 1954, and entered into force on August the 7th, 1956. The United States of America deposited its instrument of ratification of the treaty on March the 13th, 2009, and it became effective as to the United States 3 months later. The Cultural Property Convention that has become a part of our law prevents the intentional destruction of or harm to cultural property in the event of armed conflict. Cultural property takes many different forms. It includes monuments, museums, churches, mosques, temples, designated historical sites, statuary, educational institutions, and more. In other words, it is a part of the supreme law of the United States that it is illegal for the United States to strike or attack cultural property in the event of armed conflict. The treaty that prohibits doing this is the supreme law of the land of the United States. According to our constitutional law, a violation of the treaty's provisions is a violation of federal law. And that's the law. Thank you for watching.